wish to appropriate. And when such does not succeed, expropriation therefore kicks in, which then deals with what we regard as fair compensation. And the one who is not happy usually do appeal to our courts for fair compensation. I'm raising this because it is important for us to appreciate that the purpose for the state to undertake this process, firstly, is to ensure that we align the 1975 legislation to our new constitution. One of the shortcomings, if one looks at the current legislation, it actually does not speak to expropriation for public interest, which talks to land reform. There are other areas that it has not touched, which are going to be strengthened by this new bill that has been put to Parliament by the Department of Public Works. The amendment of this piece of legislation clearly defines the mechanism for expropriation. In some public discourses, as we know, regarding these amendments, views have been purported, or rather expressed, that it does not provide for judicial mechanism. And in order for us to have a better appreciation of what is in the bill, I will ask Minister de Lille in Cape Town to take us through. And I hope she will be able to help all of us to appreciate what are the aims of this legislation, what does it provide, how does it actually enable the state to undertake the work that it has in the public interest as well as for public purposes. It would also outline how this framework, so created, would actually be used by the various arms of state as well as the different spheres of government, and also what are the rights of the one who is being expropriated. As we all know, expropriation is one of the forms of mechanisms that allow us to deal with the issues of compensation. My colleague, Honorable de Lille, you can then take us through from Cape Town.
Thank you, Minister Dadisa, and good afternoon to Minister Lamula, colleagues, and the media. On behalf of the Inter-Ministerial Committee chaired by Deputy President Mabuza, we met yesterday and we agreed that today we will be updating the public and the media on the status of the Expropriation Bill 2020. The bill, like Minister Dadisa is saying, is set to replace the current Expropriation Act of 1975 that is inconsistent with the Constitution. The Expropriation Law 2020, on Friday, we have submitted it to Parliament, the chairperson of the NCOP and also the Speaker. And the bill is a framework legislation that starts up clearly how and when expropriation takes place. About the current process, like I said, we have submitted the bill to Parliament on Friday. And this follows the Cabinet's approval of the bill on the 9th of September 2020, and a further process to obtain final certification from the Office of the Chief State Law Advisor. The Chief State Law Advisor has now certified the bill as constitutional. So this paves the way for the next step in the process, whereby the bill has been presented on Friday the 9th of October, submitted to Parliament, and now the expropriation bill will be subjected to parliamentary processes which we must all respect. In terms of various existing laws, the President of the country, at least 7 national ministries, all provincial chiefs, and every municipality have powers. What is needed is a law of general application that will ensure that any act of expropriation is in compliance with the Constitution of South Africa of 1996. The Department of Public Works and Infrastructure drafted the expropriation bill following a lengthy consultation process that included the about 50,000 comments from South Africa. The department has also consulted business, labor, and community stakeholders through the NEDEC process. I must emphasize that the drafting of the expropriation bill is separate from the work of Parliament in reviewing Section 25 of the Constitution. This bill has been drafted to be consistent with Section 25 of the Constitution as it currently stands. The Chief Law Advisor has certified that it is so consistent. A bit about the historic context. Given the sad history of our country and social injustices, government is clear that land reform is urgent and there is a need to comprehensively address the consequences of the legacy of apartheid. Government is committed to restitution, redistribution, and land tenure as recommended by the Presidential Advisory Panel on Land Reform and Agriculture. Expropriation is not unique to South Africa. The ability of governments to acquire or expropriate land for the public good is something that is found worldwide. The power of governments, of a local, provincial, or national government, to take property for public use exists, for example, in the United States of America, United Kingdom, New Zealand, Australia, South Korea, Singapore, Ethiopia, Rwanda, Brazil, Mexico, Chile, France, Norway, and also Germany. Our Constitution expressly authorizes expropriation to redress injustices of the past. There are very many other examples. These powers are given different names in different places and in different countries. In the United States, for instance, the term is used eminent domain. And in India and Singapore, it is referred to as land acquisition. In the UK, New Zealand, and Ireland, it's called compulsory purchase. And in Canada, Russia, Brazil, and most of the Western Europe countries, these powers are referred to as expropriation. The bill is part of government's comprehensive approach to land reform and redressing spatial inequality and improving access to services and opportunities. The bill is part of the comprehensive land redistribution and agricultural development program. Expropriation of property with no compensation is not a silver bullet. It is only but one acquisition mechanism that in appropriate cases will enable land reform and redress as agreed by the Presidential Advisory Panel report on land reform and agriculture. Government is committed to restitution, redistribution, and land tenure, also as recommended by the panel. The bill will also bring certainty to South Africans and investors because it clearly outlines how expropriation can be done and on what basis. The legislative certainty is critical as we rebuild our economy and invest in our communities. The existing Expropriation Act dates back to 1975. The Presidential Advisory Panel pointed out that it is inconsistent with the Constitution, and the correction of this has been long delayed. The panel pointed out further that the 1975 Act undermines the constitutionality enshrined principles of lawful, procedurally fair, and reasonable administrative justice. The bill is meant to assist all organs of state, including the local municipalities where most of our vulnerable groups are located. Local, provincial, and national authorities will use their legislation to expropriate in the public interest for varied reasons that seek to, amongst others, promote inclusivity and access to natural resources which will benefit women, children, and people living with disabilities. They will have to do so in accordance with the constitutionality compliance of the new expropriation bill. One of the cornerstones of the proposed legislation is that the holders of unregistered rights in property must be treated on an equal and procedurally fair basis in the expropriation of such property. The bill retains unchanged and substantive content of the earlier bill that was before Parliament, but incorporates a new clause 12.3.4 dealing with instances where it may be just and equitable to pay no compensation for expropriation of property in the public interest. The Constitution provides that compensation for expropriation must be just and equitable, having regard to all relevant circumstances. The bill outlines the circumstances when it may be just and equitable for no compensation to be paid. It does not prescribe that no compensation will be paid in all circumstances. The bill provides that the amount of compensation will be determined by our courts. The bill further states in section 12.3, it may be just and equitable for no compensation to be paid where land is expropriated in the public interest, having regard to all relevant circumstances, included but not limited to A, where the land is not being used and the owner's main purpose is not to develop the land or use it to generate income, but to benefit from appreciation of its market value. B states that where an organ of state holds land that it is not using for its core functions, and it is not reasonably likely to require the land for its future activities in that regard, and the organ of state acquired the land for no consideration. C, notwithstanding registration of ownership in terms of the Deeds Register Act 1937, where an owner has abandoned the land by failing to exercise control over it. D states that where the market value of the land is equivalent to or less than the present value of direct state investment or subsidy in the acquisition and beneficial capital improvement of the land, and E, when the nature or condition of the property poses a health, safety, or physical risk to persons or other property. Fourthly, when a court or arbitrator determines the amount of compensation in terms of Section 23 of the Land Reform Labor Tenants Act of 1996, it must be just and equitable for no compensation to be paid, having regard to all relevant circumstances. Now, the legislative drafting process, in the process of developing this bill, legal experts were widely and sufficiently consulted to assist the department with the drafting of the bill. We are now at the start of the legislative process. Parliament will now follow its processes to consider the bill, and every South African will have the opportunity to participate as Parliament considers, debates, and consults on the bill. I want to end off with a message from Deputy President Mabuza, who chairs the Inter-Ministerial Committee on Land Reform, and he said, and I quote, "The publication of this important bill is indeed at work to realize and redress and fulfill the aspirations of the people to have an equitable society. It is a recognition of the urgency required to address the injustices of the past and restore land rights in a responsible manner, while ensuring that food security is maintained, that equitable spatial justice is achieved, and that continuation of investment to expand our industrial base is secured," end quote. I want to thank you for your time, and we are now open to take any questions that you might have. There is also a link to the bill that was gazetted on Friday, that if you want to access the bill directly, you'll be able to do so. And it's also on the website of the Department of Public Works and Infrastructure. I thank you very much. Thank you, Minister Disa.
Thank you very much. Thank you very much, ministers. Now it's time for questions. Let's start with the questions from WhatsApp. Takalani.
Thanks, Reggie. So far, we only have one question from Claudia from Business Day. And the question is, given that land expropriation without compensation provided for in the bill is deemed constitutional, for what reason does Section 25 of the Constitution have to be amended, and is the issue not moot? Thanks.
Minister Kelly, here's the question.
Yes. I didn't hear now. Can you just repeat?
Thank you. The question is, the question is from Claudia from Business Day. And the question is, given that land expropriation without compensation provided for in the bill is deemed constitutional, for what reason does Section 25 of the Constitution have to be amended, and is the issue not moot? Thanks.
I didn't hear the question. Maybe I can ask Minister Disa to respond on that side. If you heard the question, Minister, I didn't hear the question at all. It's very faint.
Thank you very much, colleague. I've heard the question. It relates to Section 25 amendment, the process that is being done by Parliament.
Yes.
What the caller from Business Day is asking is whether is it still relevant to continue with that process, given that this legislation now provides for expropriation where in certain instances it could be nil compensation. Maybe if one can respond to that question, is that the parliamentary process, as the decision was made by Parliament to amend Section 25 following an extensive consultation process, will clarify what a majority of people felt was not necessarily explicit in the Constitution. So I think the purpose for that process to continue, in my view, is that it's still relevant in terms of clarity in the formulation of the constitutional principles. What the bill, as the Minister indicates, goes further to clarify the framework around which such expropriation will happen, as well as the conditions under which it would take place. Thank you very much.
Thank you, Minister.
Maybe to add on the response from Minister Isa, if I may.
Yes, Minister, you can go ahead.
Yes.
Okay, no, thank you. Yeah, I that clarification by that committee remains important, because if this, for example, we have already had a constitutional court judgment, there will be clear certainty. So what we still have is legal opinions and academics and various experts who are saying this can be done in line with the current clause, which is currently being clarified. Thank you.
Thank you. Minister Delil, you want to add? Okay, colleagues. Can we take questions from here, from the floor? Spamandla.
Looking at the time frame here for this bill, President Cyril Ramaphosa did indicate that he would want to see this process being wrapped up by the end of 2020. We are somewhere in October now. It seems as if there is no time to finalize this by this year. Do you think this process will be finalized by this year, taking into account that there is still more that needs to be done in terms of public participation and consultation?
Minister Delil?
Yes, I can't hear the questions at all. I will have to leave it to my colleagues on that side that can hear the questions, unless they try and fix the technical problem on my side here from Cape Town.
Thank you very
But
much. Minister, I
can't hear.
will just explain the question to you and then you can respond. What the question was is, given the time frames where we are now and the commitment that was made by President that he would like to see this bill being concluded by 2020, whether we will be able to meet that deadline.
Well, as this process will now be determined and the time frame will be determined by Parliament, we will wait to hear from Parliament and the presiding officers whether they will be still attending to the bill in this quarter of Parliament before they go in onto recess, or when. But the time frame of processing the bill must be determined by Parliament. We can't determine the time frame. Since we have submitted the bill to Parliament on Friday, I'm sure by this coming week, the parliamentary process and the Speaker and the Chair of the NCOP, they can give us clarity as to how long it will take through Parliament.
Thank you, Minister. Let's take the second question. Okay. Any other question from WhatsApp? Takalani?
Thanks, Reggie. So far, we don't have questions, but I can see the questions are coming in, but they are not yet being crafted, but they are coming in. Thanks.
Minister, currently there are no questions, but there's a follow-up from ENCA, Spamandla.
On the issue of stability and policy safety, my name is Spamandla from ENCA again. Minister Delil did outline that this is set to bring that certainty in terms of policy certainty. But surely if there is no commitment or indication for now that it will be wrapped up by the end of this year, surely that policy certainty cannot be guaranteed at this stage.
Spamandla, thank you very much. I think Minister Delil did clarify that the executive has done its task. They've tabled the legislation in Parliament. And as we all know, the responsibility of lawmakers, which means once the bill is in Parliament, there are processes that the lawmakers will undertake to make sure that they follow their own processes in terms of public participation and going through the bill line by line and conversing amongst themselves on the desirability of certain clauses, and then pass the bill from the Portfolio Committee, which will then go to the National Assembly and the NCOP for approval. I must indicate that policy center, in my view, indeed, what is the framework of the bill now in being in the process in which it is? It's already giving the clarity and the direction that the executive would like to take in respect of expropriation. Before, everybody had his or her own interpretation on what the state would like to do. So I would just say, from the bill as it stands today, it does give policy direction in terms of the way in which the state is considering expropriation and how it must be undertaken. We are all hopeful that maybe before the end of the financial year, which comes to the end of March 2021, probably the reprieve also given by the lessening of the regulations with regards to COVID-19 will enable for better engagement between Parliament and the citizens, because that too has had a factor in terms of where we are. So I think, in my view, policy certainty in respect of where we are going is already emerging. But once the bill is approved, that's when we'll know for sure where is the finality from the lawmakers in terms of this law. Thank you very much. I hope, Samantha, it has clarified somehow the question you were raising.
Yes, it has.
Thank you. Are there any other questions? Yes, sir.
Good day. Simple Stillman from SABC TV News. I'm just going to move slightly to something that you touched on earlier regarding the farmer tax and the tax scheme that's being set up to address that. Now, yesterday in the Union Buildings, we had a group that said calls themselves Unite Against Farm Murders. And one of the pleas that they called for is that it's for government to prioritize farm attacks. They feel that government is not taking this issue seriously, and that if it goes on without being tackled, then it threatens the ability of the farmers to ensure food security. So what is your response to the ongoing request to prioritize farm attacks? And do you feel that this will lead to some form of threat to food security for the country if the farmers continue to be attacked?
Well, Samantha, you want to join in that question?
Yes, it's a follow-up on that one. That has just been
Before
asked
we
by
even
people.
answer it, okay?
Yes. You alluded that there is another task team that has been formed to deal with the issue of rural safety, if I can put it like that, some call it farm matters. But your critics will argue that you seem to be prioritizing a certain you seem to be prioritizing certain cases over others. In South Africa, violent crime is an issue. Why are you zooming in on one and forming a team that will deal with one aspect of it? How do you respond to that criticism?
No, thank you very much. I think, as Minister Tilil is saying, that the primary reason for all of us to be here relates to the issue of expropriation that we are having. But just to answer the question on the IMC and its concern on the issues of rural safety, you know that government has been concerned about the number of violent attacks that have been taking place in our rural communities. That would include farm attacks, farm worker attacks, farm dweller attacks, and ordinary citizens who stay in rural areas. You saw, for instance, in Tralume in the past months, where there have been a spate of gender-based violence where a number of women and children were actually violated and even killed. So rural safety doesn't only deal with attacks on farmers or farm workers or farm dwellers, but all of those who are in our rural landscape. The issue that the IMC resolved on the formation of the task team, it's because beyond just ordinary crimes, in the meeting that Minister Tlele had in the Newcastle area, where there was an imbizo that included farmers, farm workers, communities, and farm dwellers, some of the issues that was raised as matters that increase tensions among those communities related to land issues. Some of them related to the number of stock that is kept, and therefore what the IMC was saying is that let's deal with those matters because they would also assist us in lessening tensions amongst those communities. And in actual fact, if you listen to Minister Tilil on the issues when she was highlighting what the expropriation bill will also deal with, is to actually ensure that even on those areas of public interest relating to issues of land, for farm workers, for farm dwellers, such an act where the state, be it at local level or provincial or national, would like to expropriate in the public interest to provide for land for those communities, they will be able to use this law as an instrument to facilitate for the land acquisition. I think let's come back to the actual legislation, and as outlined, if there are any questions that you would like to ask. And I must say that for us it's important because as this legislation is public now, we want to ensure that more South Africans are able to engage with it. Dakalani from the WhatsApp.
Thanks, Minister. We have Laila Magnus from SABC News, and the question is what organizations or departments will be involved in the task team to investigate the rural tensions, and what is the aim of the task team, and what does it hope to achieve? Thanks.
I think I've already clarified the aim of the task team. The departments is Agricultural and Reform, COGTA, and Department of Cooperative Governance and Traditional Affairs. Let's come back on the expropriation, Goge.
Yeah, Minister, if I can just add, make an addition.
Yes.
Yes. I think it must be clear to all of us that expropriation is nothing new. In terms of various existing legislation, the President, all the provincial premiers, at least 7 national government ministers, and all municipalities have got powers to expropriate. So it is not just national that can do expropriation. What is needed and what is in the bill is a need for a law of general application that will ensure that any act of expropriation is in compliance with the Constitution of South Africa of 1996. And the bill seeks to deal with the 1975 Act that is long outdated, and many sections of that Act is inconsistent with our 1996 Constitution. I do think that when Parliament is going to debate and discuss the bill further, there will be opportunities for all South Africans through their public representatives in Parliament also to make further comments on the bill. But this is just the beginning of the legislative process after Cabinet approved the bill on the 9th of September. Thank you. I just wanted to clarify that.
Thank you, Minister. Samantha?
Yes, no, you'll have to forgive me and pardon me here, but the bill provides that the amount of compensation will be determined by the courts. I hope I'm reading that correctly. Now, there has been a debate in South Africa about that point. Some were arguing that in this form, it gives power to the courts than the executive in terms of determining how it should be settled, the compensation part and aspect of it. What do you make of that?
Okay, can I ask you to use Takalani's mic because
no, I did not sending it to you. Do you answer?
Minister Delil, I hope you can hear me now. Sipamanda from ENCA. I'm saying here the bill provides that the amount of compensation will be determined by the courts. In the past, not so long ago, I think a few months, there was a debate, particularly the governing party was not happy with that. They argued that the aspect of it takes power and gives it to the courts rather than the executive. What do you make of that? I can see that that point is back now in this new form. Thank you.
Mr. David?
Yes?
Takalani,
Yes?
Takalani,
Did you get the
allow him to use your mic?
No, I can't hear any of the questions. I'll appreciate if GCIS can WhatsApp the questions to me, then I can also answer some of the questions, but I can't hear them.
Can you use your mic?
Your mic is better. She can hear.
Or go to the podium. Go to the podium.
Mr. Koke is repeating the question for you.
Okay, Minister, I hope you will be able to hear me now. Can you hear me now before I proceed?
I can't hear.
Go to the podium.
I think maybe a better solution is that after the press conference, the journalist can call me directly and then I can answer the questions. But technology is not assisting us today. I'm sorry.
Can you come?
Come, Mr. Koke. Minister. Let's ask you a question.
I hope you can hear me now, Minister. Where do I need to press here?
Just talk.
Yeah, that sounds better.
Okay, I'm saying here, I'm reading that the bill provides that the amount of compensation will be determined by the courts. Now,
Yes.
not so long ago, there was a debate in South Africa. The governing party was not happy with that aspect of it because they argued that it gives powers to the courts rather than the executive. What do you make of that, seeing now that that point is back on this new bill? Thank you.
Well, in terms of just an administration law and also in terms of the Constitution, the proposal in the bill is that compensation will be determined by general agreement. If a person is not happy with a settlement, then of course the courts can be there to assist to get agreement to determine the compensation. So that is all in line with the existing Section 25 of the Constitution, and we will hear whether the legislators, members of Parliament, whether they will agree with the proposal from the executive or not. Thank you.
Thank you very much, Minister. Do we have other questions from WhatsApp? No question. Any other question from the floor? No question. Thank you very much, Ministers.
Thank you.
We have come to the end of our media briefing. Thank you very much.
Thank you very much. Thank you, Minister Disa and Minister Lamula. Goodbye.